All right, so now everybody's gonna get to say it's on YouTube too. So, okay, everybody. This is with Andromeda Vega Rubio. Everybody's gonna get to say it's on. Oh, wait a minute. So. Don't want the double stuff. Andromeda Vega Rubio. She's a graduate of Baylor Law School. She was a prosecutor for Williamson County for 2 years. After leaving the prosecutor's office, she opened up her own firm, A. Vega Rubio Law, and now practices primarily criminal defense. Okay, and so she's here to present a little bit about some hearings. And so I'm gonna let her take it away, and she's got a nice little PowerPoint. So go ahead, Andromeda.
All right, hello everybody. Thank you for joining me during your lunchtime. Feel free to go ahead and eat, just please don't let me see because I haven't had lunch yet and I'll get hungry. All right, so I am going to talk today about ALR hearings and driver license suspensions. I have 2 attorneys with me here today, Robin Leatherwood and Maria Toscano, and they'll just be monitoring the chat box. So if y'all have any questions, feel free to put that in there. If I don't answer your questions by the time I'm done lecturing, I'll address those questions. So let me go ahead and share my screen.
And everyone can share your bar number if you're not gonna end up putting this in yourself. Make sure you put your name, because if you're not if you're showing up as 832 something, I won't know who you are.
Okay, please let me know if somebody cannot see my screen. I think I'm actually sharing the wrong screen. Okay. Okay, for whatever reason, I keep showing that screen. All right, I'll move it here. Okay. All righty, so administrative license hearings. As far as I know, all of you guys should know what this is, but I want to approach this a little bit differently. So I do primarily criminal defense. So I want to give you guys that perspective and what that includes. So we're going to start with the case. I'm going to introduce to you David R. He's a fictional character. He is about 23 years old. He's currently studying at UT. His major is biochemistry, and he works at HEB during nights 3 times a week. He's putting himself through school, and of course weekends he may or may not go out and have a drink or 2, right? And so this is Saturday night. It's 2 in the morning, and David is out with a friend, has a beer or 2. He then wants to go home, gets in his car, starts driving. Now, Officer Peralta is parked near the downtown area, and so he sees David's car. It's driving.
You don't have to. You don't have to. Just add your name up there.
It's driving.
We can't hear.
I muted you by accident.
Better now?
Yeah.
He just
Okay.
started driving downtown.
Okay, so yes. So he gets in the car, he starts driving home. Officer Peralta, who is working that night shift, he is parked in a little corner so he can have a good view of the road. And he sees David's car driving up, right? He sees how the car is weaving in and out of, it's weaving a little bit within his lane. He then comes to an abrupt stop at a red light. The moment it turns green, he just takes off really quick. And Officer Peralta thinks, well, it's 2 in the morning. It is Saturday. He's coming from downtown. He's weaving just a little bit. Let me go and pull him over. So he goes, he pulls him over, and he makes contact with David. As he is talking to him, he smells a little bit of alcohol, and he notices he seems very sleepy. has somewhat of slurred speech. So he asked him to come out and ask him some more questions, ask him to do the standard field sobriety testing. He doesn't do so well, and so then he gets arrested. Okay. There we go. All right. I'm sure you all know about the implied consent law in Texas. What that is, it's basically saying everybody that drives in Texas is agreeing to provide either a breath sample or blood if they get pulled over and are being suspected of driving while intoxicated. Okay. So because of that, actually, let me get out of here. Can y'all see this better this way? I don't know why my computer won't. Try to make it. Okay. Trying to give you all the best view possible. So this right here is the statutory warning, right? After.
Andromeda, it's not on there.
It's not on there anymore?
We see your other monitor, blue screen.
Oh. How about. Technical difficulties, folks. Okay, how about now? Okay, perfect. All right. Once the officer decides that David is intoxicated or maybe intoxicated, he places him under arrest, right? He then reads him the DIC statutory warning, the DWI statutory warning, the DIC 2024 form. So you have, this is it right here. You don't have to read through all of it. I'm going to hit all the important points. It's just to show you what that warning looks like. So the officer has to read the person that he's arrested, the defendant. He has to read the entire form word by word to him. Okay. When he gets to the end, he asks him for consent. If he says yes, then he'll check that he gave consent. If not, then he'll check off that the defendant refused. So these are the parts of the DIC 24 forms hits. It tells the defendant why he's being arrested, right? In David's case, you've been arrested because you're suspected of DWI. It will ask him to, it says that he will be asked to provide either breath or blood, and that will be used to analyze it so that they can see whether or not there's any blood or any drugs in his system. It also educates him on the consequences of refusal. So if he refuses, his license will be suspended. It tells him the amount of time, so not less than 180 days. It also educates him on the consequences if he agrees to provide breath or blood. There will be a suspension too, but not less than 90 days. And if he's younger than 21, then it won't be less than 60 days. It also educates the driver, if he's a CDL driver, what the consequences are going to be, and that the license is going to be suspended for not less than 1 year. It tells the driver that he has the right to request a hearing, which is the ALR hearing, and that he has a certain amount of time to request that. So he reads this to David, and let's say David says, "No, I'm not gonna give breath or blood." So he's refusing, right? At that moment, his license gets suspended. However, the officer now gives him a notice of suspension and a temporary driving permit, which is a DIC 25. This is what it looks like, and you don't have to read it all. It just basically educates him on the suspension times, if he's under 21 and if he's an adult. And we'll talk about suspension times here in a little bit. But this right here allows him to drive until he either requests an ALR hearing and they go through it, or if he doesn't request one, after 15 days, the license is then suspended, right? He can go get an occupational driver's license or something if he needs one. Okay, so how do you request a hearing? Now, say David is a smart kid and he goes and he hires you guys and y'all want to help him out now. So you can go online. Back in the day, you could go and submit a petition. You could do it via mail. You could do it via fax. Some places you could even call it in, and that was very rare, but you could do that. That was way back when. Nowadays, you just go to the DPS website, you fill in these boxes, and you get, that's how you request it. It's quick, easy, and clean. After you've submitted this, it takes them a little bit to process it, especially now with COVID, every court is behind. So it may take a few months. And then the driver is going to get a letter saying, at this day, you have to show up, and this is what you got to bring, and this is how it's going to be. Now, where you're filling this out, you can request either a virtual hearing or a in-person hearing. By in-person, right now it's in Zoom, virtual is via phone. If you request a in-person or via Zoom meeting, you have certain benefits, right? You can, as a defense attorney or as the attorney, you can subpoena the officer that arrested the person. The benefits to that is if the officer doesn't show up, you win the case straight up and there's no license suspension, okay? If the officer does show up, then you still get to question him. And we'll talk a little bit more about benefits and what you can ask and what evidence can come in. But the main thing is if the officer does show up, you get to cross the officer and you kind of get to hear, right? You have a sneak peek as to what the officer will say should this case go to trial in the future. Now, if you don't practice defense law, it won't matter much for you. But if, say, you represent him just for the ALR hearing, and you know that your client will in the future hire defense attorney for the DWI, it's very, very hopeful for the defense attorney if you can just give them the records. Okay, the parties. Who are the parties in the ALR hearing? So we have the office that conducts these is the State Office of Administrative Hearings. Its DPS will send a prosecutor down. The prosecutor will most of the time just call the officer as well. The videos, if you want to play the videos, you can. The state never does because they have no need. They just ask the officer. The state will have to prove several things. So one, they'll have to prove that there was reasonable suspicion for a stop. Then the other thing is, was there probable cause for an arrest? Was the defendant given the opportunity to consent for breath or blood, right? Did the officer actually read the DIC form to the defendant or not? And then if the defendant did consent, the state will have to prove that the BAC was over 0.08. And so the burden of proof is a lot lower than if this was a criminal case. So it's only preponderance of the evidence. Okay, what evidence can we bring in? I'm sure you're all familiar with the portable breath test. That's something that the officers carry with them. They have it usually in the car. They'll offer the drivers to blow into it right there and then, just to kind of see if, you know, they pass or not. Usually it never works out for the defendant. But if they did do that during the investigation, that does not come in at all. So the officer cannot mention that they did it. And he cannot mention what the result was. The offense report, unlike a criminal case, it does come in. So that's good for you, right? Because you already get, again, if you're not going to represent them in the criminal case, it may not matter as much. But for a criminal defense attorney, it helps because you're already getting everything before the case is even filed. So you'll have the offense report that will come in. Breath results or any blood results, it depends. If the officer is claiming that this was a refusal case, so let's say David says no, and then the officer gets a warrant and they get his blood. And by the time the ALR hearing happens, they already have the blood results because they suspended his license. So they suspended his license because he refused, right? So therefore they cannot bring in the results of the warrant. The other thing is if videos, if the officer was wearing a body cam or if there was a car cam that recorded the entire stop and incident, the state will never introduce it. You can, if you want to, if you think it's going to be beneficial for you. But again, another benefit is you get to watch the video if you have the ALR hearing. If you're going to go to trial eventually for this, then it's a win-win for you because you can already prepare for any future arguments. Okay, potential arguments. One thing you can argue is lack of reasonable suspicion. So in David's case, what do we have? He was weaving within his lane, right? He never crossed to the other lane. He was just weaving a little bit within his lane. He came to an abrupt stop, and then he took off quickly when the light turned green. We can think about the other circumstances. Okay, it was Saturday, it was 2 a.m., he was coming from downtown. So all that together, is that enough reasonable suspicion to pull somebody over? Somebody wants to volunteer to say yes or no, cool. If not, I'll move on. Okay, so it depends, right? A judge may find that no, there wasn't enough, and another judge may say weaving within a lane is not even a traffic violation, so therefore no, there was not enough reasonable suspicion. If the judge finds no, then you're done. You want your hearing. If the judge says, well, maybe all put together, yes, there was enough, then you move on to your next argument, which would be lack of probable cause. The officer will have to have specific articulable facts. So he can't just say, well, it kind of felt like he was drunk, or in my gut, I knew, or because of my experience, I knew he was drunk, right? He has to be able to articulate specific facts. So in this case, again, we have the driving facts. If the judge has found that that was enough, then, the officer will be able to use it. He smelled alcohol, the SFST's results, and his behavior. So you'll have to watch the video and ask yourself, okay, did the officer actually investigate whether there were other reasons why he presented that way, right? Let's say David has a pregnant wife at home who had horrible cravings, and he hasn't been able to sleep at night because she can't sleep and she won't let him sleep. And so he drove downtown because that's the only place that was open for the ice cream that she wanted, right? He wasn't downtown because he was drunk. He was just literally getting his pregnant wife something to eat. SFST's result, maybe he couldn't keep his balance. Did the officer ask him whether he had any prior injuries? Maybe David played soccer or football or something and has a recent knee injury, right? If the officer didn't investigate enough, there's a good chance that maybe there wasn't enough PC. We had a case in our county where a man he flew from California all the way to Austin. He flew out of California in the afternoon. He had a drink at the airport. He got to Austin, I think it was like 11 o'clock. He rented a car and he started driving to his hotel. He didn't know the car. It was a car he had never driven before, a model he had never driven before. And so he forgot to turn on his lights. He had the daylights on and he didn't turn on the night lights. So he got pulled over. When he got pulled over, the officer smelled the alcohol on him from the afternoon when he had the drink in California. And then they say, well, we had enough PC because he didn't have his lights on. It was late at night. He was coming from an area where there were bars and he didn't know where he was and where he wanted to go. He just had an address, right? He couldn't locate, he couldn't tell what part of town he was in. And so they arrest him, they take him to jail. They draw his blood, they get a warrant, he refused. So they draw his blood and there was no alcohol, no drugs in there. So it was all just a huge misunderstanding because the officer didn't investigate correctly, right? He didn't ask him, why don't you know where you are? Or where do you live? Or why do you smell like alcohol? When's the last time you had that drink? So he didn't investigate correctly. And so that case was, obviously it was dismissed, right? Okay, the next argument you can do, or it's not really an argument, you can, if you find that the officer didn't read the DIC 24 to the driver, again, you win the hearing straight out. There's nothing you need to argue because if the defendant wasn't made aware that his license was going to get suspended if he refused, it's not his fault, right? The other thing you can do is you can request the maintenance records for the Intoxilyzer 9000. That's the machine that if you go to jail and you blow into it, right, it measures the alcohol level in your system. You can request the maintenance records. They'll give you the records for 30 days before your client takes a test and 30 days after your client takes a test. That way you can know, okay, did it get repaired at any point? Or was there any issues? Or did it have a bunch of, issues, right? And a bunch of problems or misreads or whatever. If DPS, however, doesn't give you the records in time, then you win the case. So there's these little things that you can do to win the case. Let's say everything goes wrong, you have horrible driving facts, and you just lose the case. You can, if you want to, appeal the decision. Of course, you have to pay the fee, but the upside to that is you've given your client more time to drive on his license. If he wants to get, if you know, because the driving facts are so bad that you know for 100% he's going to get a conviction, there's no way around it, then you've given him more time to get an occupational driver's license. For that alone, the fees in, so if he doesn't get, if you do get an occupational driver's license before he gets convicted, the fees are way less than if you do it after you've gotten the conviction. Because if you get the conviction, you've got to get the ODL in a court of conviction, and we're talking $500 and up. If you do it at a JP level, it's only $50 and up. So it makes a huge difference for your clients, money-wise. Okay, suspensions. If you are a minor and you're so younger than 21 years old, if you refused and it's your very first offense, your license will get suspended for 180 days. Now, if you have previously been suspended already for failing or refusing, or if you have one conviction, your license will get suspended for 2 years. If you consented, then, and it's your first offense, then your license gets suspended for only 60 days. If you were previously convicted or refused, then 120 days. And if you've been convicted twice or more, it's for 180 days. For adults, if you refused and it's your first offense, it's 180 days. If you have been previously suspended for refusing or failing a test, or if you have a conviction, it's 2 years. If you consented at the scene, or if you consented right after you got arrested and it's your first offense, it's only 90 days. But if you've been previously suspended for failing or refusing, or if you have a conviction, then it's 1 year. And all of these suspension times are on the DIC 25 form I showed you, the one that serves as a temporary permit as well. Okay, there was a legislative update here not too long ago. That one reforms the 180-day license suspension. I think for that one, me personally, the way I understood it is it's more related to misdemeanors involving drug offenses, not alcohol. So y'all may have to read into this a little bit because I haven't dealt with it yet. I just want to make you aware that it's there, and it's the House Bill 181 if y'all want to look it up, because it is a big jump from 180 and it reduces it to 90 days. So that's always helpful. Let's say David is not even from Texas and he had a driver's license from Florida, right? And obviously Texas can't suspend your driver's license if you don't have a Texas driver's license. So how does it affect out-of-state drivers? There is an agreement, an interstate compact between a lot of the states in the United States. Not all of them are part of it, but most are. And what they do is they exchange all information about what happens within their state. And the other state is supposed to, I guess, suspend that driver's license as well. So if David is from Florida and is driving in Texas and Florida is part of one of those states, then Florida would suspend David's driver's license in Florida. So he would have to go and, deal with that down there. Okay, so benefits of an ALR hearing. And I just see that I forgot to actually type the number there, but I'll just tell you. So if you win the hearing, obviously that's the biggest benefit, right? No license suspension. If you have an actual hearing, whether it's via phone or in person, everything is recorded. However, all the recordings, all the documents, everything is destroyed after a certain period of time. I'm not 100% certain on this. And I double checked with 2 other attorneys and they confirmed. So if y'all know differently, please let me know. It's 180 days that they hold on to it and then they delete it if nobody requests the recordings. The other benefit is, again, I mentioned that earlier, it gives your client more time to get the ODL. And then the defense attorney kind of gets a first shot at what is trial going to look like. Is it going to be worth it for us to go to trial, right? If the officer sits there and he doesn't prepare, then he won't know the facts very well. And if he says something that helps our client or something that didn't happen, something that's different from the offense report, then we can always use that against the officer if it goes to trial. If he does prepare, then at least you get a sneak peek at what he's going to say. Okay. Any questions? I feel like I rushed through this really quick. And it's either 32 something, and I don't know if it's just bar numbers. And it looks like it is.
Yeah, those are basically the bar numbers.
Okay, is there anybody that wants to share a story or correct me on something I said?
I have a question.
Yeah.
About the license suspension. If the defendant doesn't send a money order of 125, does the suspension continue?
Do you mean after the suspension time
suspension,
is over?
Yeah.
Yes, you have to pay the 125 in order to reinstate your driver's license again.
Yeah, that'll make it an indefinite suspension until they pay it. So if you have a client that has like a suspension and it kind of doesn't make sense because the suspension period is over with, but you still see like $100 or something like that, then what you'll want to do is just have them pay that, and usually that'll remove the suspension. But if you win the hearing, then they shouldn't have to pay it.
Right.
That's all.
Are there any questions?
Oscar, did you have a question? I see you're unmuted.
Andy, there is a question in the chat. How long after the arrest does the defendant have to request an ALR hearing?
Okay, that's a good question. So you have 15 days after the arrest to request it. If you miss that 15-day deadline, then you don't have the right to the hearing anymore. So
What I
really,
suggest for anybody is like, if you find that your client has missed a date, they basically hired you like after 2 or 3 appearances, get them to ODL, because they may not get a ALR hearing, but their license is suspended and they probably need to be able to drive. Let's see, there's another question. If we win, how does the suspension get lifted?
so you get a order, and then you just take that to DPS and let them know, and they'll put that in their system.
Yeah, so I think basically the license is technically not suspended. It'll show as like eligible instead of not eligible. And so technically the license isn't suspended anyways. But the way you get it removed so where it's not anybody seeing it is by doing that. Let's see, the next question is, what is time discovery must be given to defense attorney to argue it is late? From Oscar.
Oh, are we saying for the DPS for the maintenance records or for just any evidence?
Oscar, if you could put in maybe a clarifying, that was a little weird to read it. Next thing, Ken put, what if the defendant refuses? When exactly does 180 days start? Also, will the suspension begin after the 40 days, or will the DOS wait for blood results?
So if I get arrested today, right, for drinking and driving, for example, and I'll get the temporary permit for 15 days. If I don't do anything for 15 days, then at that point my license gets suspended and for the remainder of the time, right? If I get 180 days, and that's the time that my license will get suspended for, and then I pay the fee and then it gets reinstated. So they won't wait for blood results unless they're arguing. So let's say that's if I refuse. If I agree and I say, yes, I'm going to give breath, then they take me to the jail. At that point, I would blow into the intoxilizer and then I would get the results right there and then, right? If it's above a 0.08, then same thing. I get 15 days and then the suspension goes into effect. If I say I'm going to agree to provide blood, then we would have to wait for results to come back because they can't suspend me for having driven while intoxicated, right? They can't prove that up yet. So they would have to wait until they can prove up their case and suspend my license then.
Oscar, what was your question? I see you have your hand raised.
That the discovery on anything when we argue to the discovery was not timely, and then we can use it for dismissal of the.
Okay, I think I understand your question. He's asking what is the time frame for when discovery is late?
Oh, okay. So with ALR hearings, it's a little bit more lenient than with a criminal case or even a civil case. So as long as you get the discovery, a few days before the hearing, they're fine. Also, the day of the hearing, everybody is entitled to automatic 5-day reset. And then each side is entitled to a one-time reset for any reason. So really, if DPS doesn't get the paperwork to you, say the maintenance records, right? And the hearing is going to be in 2 days, they can just ask for the 5-day reset. And if they still don't have it then, they will probably file for one continuance and they would get that. And because every court is so behind, it may give them another 3-4 months before you get a new hearing date.
What, Oscar, you can expect is that if they don't have it the first time, then they'll get a continuance. And then the second time, they'll probably end up dismissing it. But if they ask for a continuance, specifically, if it's not given within 2 days of the hearing, usually you can suppress whatever is given within 2 days, I believe. Okay, next question is, I don't remember if I read this one already. If the case is dismissed at the ALR hearing, can you recover your confiscated Texas driver's license?
Yes, and sometimes the officers won't even take your driver's license. I've had a lot of clients that still have their physical driver's license. So, I mean, if the officer actually goes through the trouble and takes it with them, then yes, you can go ahead and recover it. There is no fee or anything like that. You just request it. But more often than not, I see them not confiscating them.
We get a lot of confiscations here in Harris County. Y'all must
Oh,
be
really?
better than us. Clients can also request a new one because technically their stuff isn't suspended until either they miss the deadline for the hearing or they get an affirmative finding. So they can also request basically, lost, stolen driver's license, and then they'll have a driver's license because it'll still technically be eligible until it's suspended.
Right.
Let's see here. Next question from Gilbert Rodriguez. Is the presentation, oh, that's from me. Yes, it'll be on YouTube and you'll be able to rewatch it. Let's see here.
And I can set the PowerPoint presentation if somebody wants it. Y'all can email me and I can send it to you guys as well. I don't mind sharing it.
Can you put DPS? Ken McDaniel put DPS. I'm not sure what that was for. Dealer asked, how do we request discovery and what is the DPS required to submit as discovery?
So they'll give you what you ask for, right? If you want if they're going to admit the offense report, which is what they most of the time admit, then they will share that with you. You guys can agree on it, and then it gets automatically admitted. If you want the video, for example, right? Because you want to watch the video, you would just communicate with them. I've learned, at least here in Williamson County and Travis County, is a lot less formal than the county court of laws and the district courts, right? You can just ask them for it and say, hey, I'm hereby requesting Officer Peralta's body cam or Officer Peralta's car cam or whatever, and the offense report, and if he took any pictures, the pictures, and then they'll start giving you the evidence. And then if you would like to admit something, then you would just talk to the state again and say, hey, I would like to admit the video and play this part, and then y'all can agree. And then during the hearing, it gets played if you would like the judge to watch it.
Steve, did you have a question?
Steve Watkins,
Steve Watkins.
can you hear me? Yes, I was just tapping it out. Hey, look, as is frequently the case where we are awaiting blood results, put in for a hearing, they say, sorry, we're waiting for blood results, and don't call us, we'll call you. Well, I'm afraid of that because when those blood results come back positive, I have 15 days. Where can we go? Any suggestions to just to call every couple of weeks, the DA or who, see about what the blood result would be?
So if it's, depending whether it's a misdemeanor or a felony case, right? Unless it's his third or fourth DWI, probably going to be a misdemeanor. So you can reach out to the county attorney's office. By then they have filed it already, or they at least have it in intake, and they can tell you. So if you don't want to keep calling DPS, you can start harassing the county attorney.
The local DA, okay.
Right. And then you can, and they can actually tell you exactly what number, because they have a list of cases, right? And they're going as they come in. And so they can give you an exact number. They can say, okay, your client is case number 170. So you kind of have an idea of how much longer it's going to take. If you call in 2 weeks and now he's number 100, you know you're going to have a little bit more time. So you can call maybe 3 weeks later, and then they'll tell you, okay, he's number 60, and so on, right? So you can keep track like that.
Okay, there's something to put on a tickler after about a month, call the local DA, see what's happening.
Right.
Okay, appreciate that.
I remember the blood results, if it's a refusal, they don't actually need the blood results, but it's really great to, DPS will usually get the blood results even before like Harris County will get it. And so then you'll kind of know where I've gotten cases dismissed because it was below, and I haven't even gotten the DIC or the OR from Harris County, and then I just send them what DPS sends me. But if it's something that they consented to, then that is something that they will need to prove up. And if they, connecting to Oscar's question, if the first time they didn't have it, and then the second time comes around and they didn't, and they got a continuous the first time, they're not going to get a continuous the second time. They'll usually just go ahead and dismiss it. Julian Rios, do you have a question?
Well, can you hear me?
Yes.
Okay, this is Robert Utzer on Julian's computer at my office.
No problem.
So Steve, just my comment on when there's a consent. I mean, when there's a consent, sometimes I've seen officers not send the stuff up to DPS at all, and even though they come back way above the legal limit, they don't even have the AR here sometimes. So I don't like to rustle rustle the bushes with the DPS. I don't want to wait. Of course, if there's a failure, it doesn't matter. You've already requested a hearing within 15 days. You're not going to get one of those funny letters because the hearing, your request was timely. Because he refused. You requested within 15 days, and then it'll just proceed. So you won't get that letter that it's not time yet.
Okay. Well, thank you.
Yeah. So basically, if somebody refuses, request it, right? Always request it, because that's all they have to prove. He refused. That's it. If he consented, that's where you can get more time, and you wait for blood results and you wait for everything else. But if there's a refusal, always go ahead and ask for the requested hearing.
Okay, thanks.
Next question we have here, what are the arguments defense attorneys make for attacking the forms DIC 23, 24, 25 and report discovery if it's incomplete?
So that's a really good question. I actually was going to say something about it and I completely forgot. So thank you. So the DIC forms, they get updated regularly. If an officer uses the wrong DIC form, right? Say it's the older one and something changed in the law or anything changed, because remember, they have to read it verbatim. So if it's a different form because it got revised or for whatever reason, you get that kicked out and you win the hearing. So make sure that the officers read the revised most, actual forms. That's one thing, is a lot of officers, they just have a bunch of DIC forms in their car and they leave it there until they run out. So they may or may
Andromeda,
not
can you
use an
bring
older
up
form.
your DIC 24 you had up there?
Sure.
If you look at the top right-hand corner, that's
Right
the
here.
revision date. Sometimes they'll have like 9/01, and that is totally wrong.
Right. So you see the year up here, and I actually have it. Let me see it. I can pull up the actual form so y'all can see it better.
There are other forms as well, like DIC 56 and the DIC 23A. It doesn't always come in. It's not always a way to win, but those are other forms that you gotta have to, they use to make their case.
Can y'all see that better? I don't know if that helps or not.
Yeah,
but-
that's pretty
Okay,
good.
so yeah, up there, it'll tell you when it was revised, so you want to look at that. Also, if your client is maybe a Spanish speaker, he has to read it to him in Spanish. Can't be in English because he won't understand, right? So make sure the client actually understood what the officer was telling him. So it can be an officer reading it in English and another officer translating, right? And maybe not the exact words. Unless the other officer knows it word by word, another officer should not be translating. They have to read it to him in Spanish verbatim.
Can we switch, this from Diller, can we switch from telephonic hearing to in-person Zoom? If so, what is the process?
So when you request a hearing, you'll choose. If you choose virtual or via phone, say, and then you want to switch it to Zoom, just reach out to DPS and let them know that you would like to change it, and then they'll accommodate you.
Yeah, I think you just call in SOA, or you can even do like a venue change.
Right.
If you really need to, but they usually just switch it.
Yeah, it's fairly easy.
Gilbert Rodriguez, any helpful info on commercial driver's license suspensions?
So they're a little bit longer, and I think I had that on here. So the suspensions are going to be a little bit longer, right? Obviously, CDLs are, I don't like CDL because there's nothing really we can do. Just because it is governed by federal laws, not state law, so that even the prosecutors, even if they want to, they can't really do much. They don't have the discretion. So I haven't had a CDL ALR hearing yet. What I would do is I would really just try to attack every single aspect of the stop and then appeal it if I lose it. Because it's like Ruben said, right? They get the appeals. Nobody really cares about these types of cases, or yeah, nobody really cares. They're going to focus more on the DWI case. So I would appeal it in order to get rid of it. Obviously, the person will have to deal with the criminal case then, and
So I have a
that would
comment
really
on
just
that.
depend on the facts. What's that?
When you're finished, I have a comment on the CDL issue.
Oh yes, please go for it.
This is Robert Utzler. So it's not a CDL suspension. It's a disqualification to drive as a CDL driver if you lose the hearing or if you're convicted of DWI. It's a 1-year disqualification. You can get an occupational license, but not for CDL privileges. If you
Right.
win the ALR hearing, there's no disqualification. There's no suspension either. So you want to attack the hearing just like you would anything. And then if you lose, he's going to get disqualified a year and you can't do anything about it. You can get him an occupational license for the regular driving privileges during the suspension period. Same goes for the WI. If he gets convicted, it's a 1-year suspension. I mean, disqualification, it's a suspension also, but it could be a first offense and you're not suspended on regular driving privileges, but you're disqualified for a year for, as a CDL driver to drive a 26,000-pound truck.
Right. Yeah, no, you're correct. Thank you for clarifying that.
Okay, so one quick thing I want to do, because I know some people are on cell phones. The number is 174-135-5956. 174-135-5956. I'm going to repeat it at the end. Andromeda, can you speak a little bit about the DIC 56?
The DIC 56.
Mhm.
Yeah, let me pull that up so I can share that. That way we can all look at it. Okay, can you all see that?
Yeah, I can see it.
All right, perfect. So this is just, again, if somebody consents to provide breath, then they get taken back to jail, they blow into the intoxilizer. The person that is giving you the instructions on how to blow into the intoxilizer, where to stand, how to do it, right, and that operates the machine, he has to be certified to work on that machine. He will take some classes. It's not a lot that he has to do, but he'll take some classes and he gets an actual certificate, and that's the only person that can do it. So they will fill out this affidavit saying, my name is so-and-so, and I am, you know what, I'm lying. Okay, never mind, backing up. I'm mixing up criminal with this now. So, okay, what I said is true. So the person that does the test, yes, he is certified. But then there's another person, he's the supervisor that comes in and works on all the intoxilizer or the breathalyzer machines. He's the one that does the maintenance. There is some, when he does the maintenance, he's got to add some fluids in there. I don't know what all that is. I've seen it done. I don't know the technical items of it, but he has to mix some stuff. So he has to calibrate it so it'll work accordingly, right? That would be the person too that would come and testify. So if you request the records for the machine 30 days before and 30 days after, the person that the technical supervisor, the one that maintains the machines, will be the one that will fill out this affidavit, and he will say, okay, hey, I am over 18 years old and I am the custodian of this record. I'm the one that keeps up with these machines. I'm the one that prints out the reports. If something goes wrong, I'm the one that will fix it. I'm the expert on this. You can ask me anything you want. So if you request the records, you can subpoena him as well to come in and testify. Same for criminal cases. Actually, for all criminal cases, if there is a breath test involved, that person will get subpoenaed and questioned as well.
A lot of times officers forget to get the breath test supervisor to provide this. And so if you don't have this, it's a good way to win a paper case if they don't have that.
And as you can see, this one hasn't been revised for a long time, right? It says 2001. So let's just keep an eye on that one. This is the most current one, but
Any
just in
other
case.
questions?
And just to let you know, the DPS website has all of these forms online. So if you look at which one the officer used and which one's the most up to date, you can just go to the website and pull it up and you'll see which one the most recent one is.
Oscar put, during Viva, machines were not calibrated.
My question was that sometimes during the COA, there was a letter saying that they were not going to calibrate the monthly calibrations, and therefore there were so many months that were not calibrated, and we were, somebody told us that we could argue those cases to validate the results because of that lack of calibrations or maintenance or whatever they do every month.
So during COVID, you're right. During COVID, they changed their policy and they said, we're not going to calibrate anything. We're not going to do any maintenance on these machines because it was just too dangerous, right? To send people in jail. There's a pandemic going on. So yes, that's right. For a good amount of months, a lot of machines did not get calibrated. However, while I was still working at the Wilco prosecutor's office, I actually had a trial case, and defense attorney did try to argue that very same argument, that it should not be invalidated because they didn't follow their protocols, because it has to be calibrated every 30 days, because it has to be maintenance done on it. We argued that no, that it didn't matter. We put the technical supervisor on the stand, and he did say that these machines do not need to be calibrated every 30 days. They do not need to be maintained every 30 days. They just do it just to do it. And their office changed their policy so that it didn't require for them to go and do maintenance and go and calibrate them every 30 days. And because their policy changed, that argument really doesn't help, right? We can only argue the policy and, hey, this guy didn't follow the policy. He didn't do what he was supposed to do, and therefore the results are no good. But because their policy changed internally, there was nothing that the defense attorney could argue, and the judge agreed with us, and the results came in. So I guess you could try to argue it. Somebody tried and it wasn't successful. So that's just.
That was in your DWI, right?
That wasn't a DWI.
Yeah, so just remember, ALRs, they're not as lenient as the DWIs. Some of the stuff, when if they read the wrong year in the misdemeanor court, they might actually let it in, but they're just not going to let it in on the ALR version.
Right.
Anybody else have a question?
Yeah, I have a question. This is John Jaworski.
Go ahead.
Okay, the question is this. I had a situation just recently where the ALR court had a hearing date scheduled for one date. Then they sent me a notice for a second date a week later. So I didn't appear at the first one because they had reset it to the second one. They consequently suspended my client's license for not showing up at the first one. So I filed a motion for new trial and to set aside the default.
Mm-hmm.
They denied it, saying you didn't appear at the second one, so we're denying it. And I'm like, well, if they suspended the license, there wouldn't be a second one. So I filed another motion for new trial and motion to set aside the default, arguing that you shouldn't have done that because you're the ones that set two hearing dates. Tell me some advice on what I can do.
Oh gosh, you know what? I probably would have done the same. I probably would have filed the same motion. I've learned that when municipal courts and JP courts, they're just so busy, and they tend to reschedule a lot of things. So when I get one or two settings, there are so many few days within each other. For future references, I guess hindsight is always 2020, right? Maybe check in and call. I don't know that there is much more you can do that deny both motions. Maybe Ruben, do you know anything?
No, did they deny the second motion?
I haven't heard yet.
Okay, you haven't heard.
If they deny the second motion, then you should just straight up appeal, because it's like that's not within their discretion.
On the first motion, I was calling the ALR almost every other day to find out if there was a ruling, and almost 3 or 4 weeks went by that my client's license is suspended, and they didn't respond. And finally they responded and said, oh, well, we overruled your motion because you didn't appear at the second one. And I'm like, so
Oh.
just getting a hold of people is tough. Nobody answers their phone or nobody knows what's going on. It's real
Hey,
frustrating.
John,
Yes.
this is Cindy Owens. I appealed something similar up in Montgomery County, and it happened to be on a CDL guy, so it was really important, but I won on appeal. The county court judge said that I should have, whatever the problem was, that they shouldn't have gone. Oh, I think I subpoenaed the officer and they declined to let him, they said it wasn't right. And so, but it was right. So they said, so I won the hearing. So, so it was a lot of trouble to appeal it.
Well, the problem is,
but I did win, and you have very limited time there that it stays, the suspension.
Yeah, the problem is the thing is still suspended. It's been a month now, and your client's sitting there driving around with a suspended driver's license.
Yeah.
Yeah, you might want to, since they already gave you a ruling based on the other one, you may want to actually just straight up appeal it. That's what I think you might want to do, because like Andromeda said, while it's on appeal, it shouldn't be on a suspension.
Yeah,
Right.
I'll try it. I'll see what happens. Thanks.
Okay, anyone else? Oh, wait, let's see here. Oh, what is the process of appeal? What forms and where does one get it?
So I don't do appeals at all. I hate them. So I know, Ruben, unless you know, well, it's Cynthia wants to share, and she just shared that she did one.
I'll try and see if I can get some. I haven't had any ones that I've actually had to appeal. Generally speaking, the way that I operate is if I lose it, I've actually learned something today, because generally if I lose it, which I've actually only ever had this once, I directly ask for the ODL. Like I try to do that almost immediately, get that hearing date. So I didn't know that I could, that we could just appeal and then rush to the JP court. Actually, that was a question I had for you, Andromeda. What are the dates that you're putting down on the ODL for the JP court, since it's an appeal? So you're not technically not going to know the dates of the ODL, right?
So you're saying if you appeal it, but try to get an ODL at the same time?
Right, that's what you were suggesting earlier, right?
Right. You can, if you think you're going to lose it, then yes, you can start an appeal so you have more time. I would put maybe from that moment on, just starting that day for however long I think the suspension is going to be. So maybe for a little longer to add the time of the appeal.
One thing I have noticed, guys, is that if it's a municipality, not Houston related, because Houston is basically almost the same as the sheriff's office. Sheriff's office and probably the constables and also HPD, a lot of times they will not show, but if, let's say it's Deer Park, Jersey Village, those smaller municipalities, those officers might show up. So you might want to prepare to see, if the paper case is bad and you're anticipating that the officer is going to show up, you might lose it. So that might be one of the things that you want to do, is like apply for the occupational maybe beforehand and then just kind of go from there.
Right. I did have a conversation with the detective yesterday who did DWIs for a long, long time. And he did say that back before COVID, the officers, because they were in person, the hearings, they were a little bit more lenient and they could miss one or two and they wouldn't get in trouble. But now, because it's via Zoom, the officers will get in trouble if they miss. So they will more likely than not show up now. Unless there's some conflict, right? They're working or they just can't for whatever reason.
Also, You gotta pay
I
them
was-
like
let me-
$10,
I was
a
gonna-
$10 fee.
Yeah, I was
yeah.
gonna say on the appeal stuff, they're very strict. The first thing you gotta do is start requesting transcript. And you gotta find out who did it, you know, who's there that can do the transcript. And I think everything has to be done by like email, if you mail it, or some stuff has to be done by mail. And they're very strict that you follow their guidelines. If you do fax it instead of do something else, you know, I barely found out and I was able to correct it. But there's, you know, 100 ways that you can lose the appeal by not following their appellate rules. But the big thing is first start trying to get the transcript transcribed, because that takes the longest, and you're on a deadline, because I think it's only 90 days that its license suspension is stayed, or 180 days. After that, it's back being suspended. So anyway,
Cynthia, are
that's
there,
as far as the appeal, huh?
Cynthia, are these local rules? And if
No, these are,
so-
no, these are all, when you're appealing the ALR. It's the SOA rules.
So how can you
They
find
have
out?
them, they have them out. They have them out.
Okay,
So, but you need to specifically look, you know, under the appeal. Or they'll give them to you. Yeah, but I've got a copy, but yeah.
oh,
So
nice.
it's not what, this is the opposite of what I was used to doing. So anyway.
Oh,
but
okay,
I
so
I only
we've hit,
did one and I did one, so, you know.
Okay,
okay, so we've hit 1 o'clock. So what I'm gonna do is I'm gonna stop the